On the record, appearances are as they were before. The record should reflect that Mr. Brooks continues to appear from the other courtroom. I would like to make a record regarding the audio and visual from the other courtroom. I've asked that one of the bailiffs who was present during the last session, present in that courtroom, come to this courtroom. I'm going to put him under oath and have him testify about the audio. I also have information from Zach Tremaine, our IT specialist. He too will take the witness stand, and I just want to make a full record of, he did a decibel reading regarding the audio as well. All right, we have Deputy Kibler. If you could take the witness stand, please. Sir, could you please raise your right hand? Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
It is.
Thank you. Please have a seat. Please state your first and last names for the record.
First name is Nicholas. Last name is Kibler. First name Nicholas. Last name Kibler.
Thank you. And you are a Waukesha County Sheriff's Deputy?
I am.
And have you been assigned to work this case?
I have.
And were you present in courtroom 20 this morning with Mr. Brooks when he was removed from this courtroom to that courtroom?
I was.
And did you make any personal observations regarding the audio and visual setup that we have over there?
Both the audio and visual were working properly. The audio was a lot louder than it has been in the past while we were in that room.
Did you have any difficulty hearing the court?
I did not.
And then, of course, you could see through the cameras from this courtroom into the neighboring courtroom.
I could.
All right. That's the only record I wanted to make. State, have any questions?
Just briefly, Deputy Kibler, the defendant asked many times if he was muted or unmuted. Do you remember that?
Yes.
Can you confirm that even on the occasions when his microphone was muted, the audio in the courtroom continued to work?
It was.
And at any time while Mr. Brooks was muted, or even if you didn't know, at any time did Mr. Brooks ask to be brought back over to this courtroom, sir?
He did not. He is telling us he prefers right now to be in that courtroom. He did not want to come back in here.
All right, thank you. Those are all my questions, Your Honor.
Mr. Brooks, you are unmuted. Do you have any questions for this deputy?
No.
All right, thank you. You may step down. All right, then I'm going to have Zach Tremaine also take the witness stand. Do you have? I have it on my screen. Can you do a project it, please?
I think can I just share it? Like if I share the clerk screen?
Yes. All right. There is, first of all, sir, stand and raise your right hand. Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right, thank you. Be seated. State your first and last name for the record, please.
Zachary Tremaine, Zachary. Tremaine is Tremaine.
All right, and what is your position with the Clerk of Court's office here in Waukesha?
I'm the IT coordinator for the Waukesha County Circuit Courts.
Were you in courtroom 20 this morning following Mr. Brooks being taken to that courtroom?
Only temporarily. I was there when the call started, and then we came back to do a measurement of the DB meter later.
There's a document or a photograph that's displayed on the monitors throughout this courtroom. Can you tell me what we're looking at?
So my phone is in the photo, overlaid on top of what we call the X panel. It is our AV control panel. So you push buttons on it and actions happen into the courtroom, AV related. At that time of the photo, my phone is registering 67.3 decibels in that courtroom, and that was when the judge or the court was talking, and then the sound was coming over the speakers in the other courtroom.
And what, if anything, based on your training and experience, can you tell me 67 decibels means?
It's plenty loud. For comparison, I did a quick reading in the media pooling room, which is CG6 in our courthouse. The meter there was reading between 55 and 65, so it's louder than the audio feed going to the media right now.
All right, thank you. Any questions from the state?
Sir, I'm looking at the photo, and Your Honor, for the record, this photo will be made a court exhibit?
Yes.
Okay. I'm looking at your phone screen, and it looks like in the upper right-hand corner, it appears the time is either 9:26 or 9:36 a.m.
On my phone, yes, I believe our AV processor, which is the other time of 9:23, I believe that just needs to be updated, but
Okay,
it is approximately 9:26 when the photo was taken.
okay. Those are my questions.
All right, thank you,
Wait,
Mr.
I'm sorry.
Oh, go ahead.
Do you happen to know what the decibels are in this room?
I don't. I'd have to pull the same thing up on my phone while people are talking.
Okay, thank you.
Mr. Brooks, any questions for this witness?
Yeah, for the record, I don't consent to being called that name. Do you know anything about the hearing when someone has the hearing loss in any of their ears?
I do not.
So it'd be fair to say you don't know if I can hear everything good from this courtroom.
I can tell you what the readout of the room is. Beyond that, I don't know.
Well, I can't see what photo that everybody else is in there seeing that was supposed to be made an exhibit. I have not viewed that, so I don't know what's being referred to when you refer to the picture.
I'll have to show you that in a different way. I don't have the Zoom up and running, which would have been the mechanism to allow for an exhibit to be displayed. I can start that and have that up momentarily. Fair enough. So give me a moment. For the moment, we'll print it in black and white so you have it until I can get the Zoom up. Sure.
You are in the meeting now.
I need to get the other courtroom in, so just one moment.
You have to hang up after the call.
Will I have to stop the Polycom, Zach?
Yep, you have to hang up and then join into the Zoom meeting.
Okay, hold on, please. Can you do that?
What do I do?
Stop the call Polycom to Polycom, and then I'm going to call it in through the Zoom so I can share the screen with the exhibit, which will actually help when we do jury instructions.
Copy that. Hang it up. So are you calling again?
Yep.
Okay, good.
Except now both room systems are out, so hold on. One more.
You are in the meeting now.
All right, so the record should reflect that I've now changed the audio visual from the Polycom unit to the use of Zoom. I've called in both courtrooms, and they can hear from over there. And then I'll do, I just need to get back on so I can get the email. Give me a second. I have to go from double screen to single screen the way I sign in, but that'll take me just a second. And then I'll share screen so the color exhibit can be viewed by the defendant. All right, now the court is sharing screen and the image is being displayed.
Yeah, I see it.
You see it? Okay, thank you. Any questions regarding that then, sir?
My question was, pretty much already answered. You don't know if me myself can hear everything good in the courtroom, correct?
I do not, correct.
No further questions.
Okay, thank you, sir. I'll stop sharing. Okay, thank you, Zach. You can step down. All right, I just wanted to put that on the record since that was an issue raised by Mr. Brooks previously. Now, I need to get a copy of the jury instructions. They were quite lengthy. The record should reflect that Mr. Brooks was provided with a written copy. It's 107 pages, and the state was provided with a written copy as well. Again, it's all the same, 107 pages, and then my written copy is on its way.
I set the value, return the value each document. That's if I'm not muted.
You're not muted.
I also would like to again ask for subject matter jurisdiction to be proven on the record.
Your request is
It
denied.
has yet to be verified. It has yet to be verified.
Your request is
Your
noted.
Honor,
It's denied without further hearing or consideration.
I was just told that the evidentiary phase is supposed to be closed. How come I haven't been able to present my evidence into the record as I've asked numerous times on the record to be able to do? I've said I have numerous documents that needed to go into the record. Why have they not been permitted to be made evidence? I didn't rest my case, so I don't know why that's being told. And I have yet to be able to offer my exhibits into the record for evidence. How is that so, Your Honor?
So the court did declare the evidentiary phase of this trial closed. I specifically found that you forfeited your right to present any further evidence or testimony when you failed to answer my questions regarding the calling of witnesses. And then I also declared that you forfeited your right to testify. Specifically as it relates to your trial filing, sir, I would note that all evidence in a trial must be proper, it must be probative, it must be relevant, and it must follow all rules of procedure and all rules of evidence. To the extent that you wrote all of those documents, sir, that would be hearsay. And for that reason, I'm denying your request to make them part of the record.
They were not hearsay, Your Honor. I did what you told me to do. You told me, since I was representing myself pro per, that I had to write everything out and present them to the court.
So that's not what I said. You're misquoting me, but in any event, I'm
No, that's
denying
what
your
you said.
request. I
So
said,
you're saying that I have no right to present evidence and to have exhibits as the state's been able to do.
Mr. Brooks,
Are
I'm
you
not
denying
going to
me my-
have a debate about this
Are you
now.
denying me-
I gotta
are you
mute him
denying me
once
your
again.
right?
So, Mr. Brooks, I have muted you because I declared the evidentiary phase of this trial closed. You forfeited your right to present further evidence and testimony previously by refusing to answer the court's questions. I will specifically address the filings. Number one, it is not true that I advised him that any filing would become evidence. That is simply false. Number two, filings, I told him if he wanted to present motions, should be written down and should be based in law and fact and request specific relief. I'm well aware that previously he has referenced he would like his filings made exhibits. I've reviewed those filings. There's nothing relevant, nothing probative, or the information contained therein is hearsay. Mr. Brooks would have needed to testify regarding any statements that from himself, testimony. He cannot simply put in an affidavit. That's not proper. That's hearsay. And he hasn't asked in any of those filings that he hasn't put forth any exception to the hearsay rule that would allow this court to admit his written filings. I believe, without fail, they are all irrelevant, not probative, and hearsay, and therefore not admissible. So we're moving on to the discussion of jury instructions. When Mr. Brooks wants to abide by the rules of decorum and civility, I will unmute him. He clearly just took the entire packet of jury instructions and put them, I don't know what's under the table, if it's a garbage can or if he just simply put them under the table, but they are no longer in front of him. I will, however, unmute him so that we can get his feedback regarding jury instructions. It's typically a back and forth. We'll go through them, and I'll ask the parties whether there are any instructions they believe should be included, and we'll have a discussion on that, and then we'll talk about whether any of the instructions that are in here need to be modified in any way, taken out, edited, etc.
Beauty.
All right, you're unmuted now, but you have to not interrupt.
You can't, I'm not trying to interrupt, but how can you deny me the chance to put on the adequate defense by saying nothing that you told me to do can be presented into evidence? So you filed them. You filed everything that I gave to you.
All right, Mr. Brooks, I'm going to mute you because this is not relevant at this time.
It is.
He's raised tone of voice. He's very animated. He threw the jury instructions on the floor. I understand you're upset, sir. I understand you believe I'm violating your right to present a defense. I've made my rulings. I determine you forfeited your right to testify, which includes the right to present evidence as you would have testified. I closed I closed off your ability to call any other witnesses by finding that you forfeited your right to do so based upon your conduct. I understand you're frustrated. I understand you believe that I'm not without authority to do that. I made specific factual findings. I've referenced the law, and you being upset with the decision is not going to change my mind. He's also taken the headphones off. It's his choice right now whether he participates in this jury instruction conference. It is his choice. But if he is going to spout off about things that I've already determined, I will continue to exercise the mute function on the audio equipment. I'll unmute him again, but you are advised, sir, you need to be proper, you need to not interrupt, and you need to stay on task, which is we're discussing jury instructions, not other evidence, not subject matter jurisdiction, not your belief that I told you to file things a certain way. We are now discussing jury instructions.